Good morning, everybody. This morning, we're going to start with remarks from a member of our federal judiciary. We had a few themes yesterday that I think are worth just briefly mentioning as we go into this remarks and discussion. One was actually about money and corporations and the ability of the US dollar and the US financial system as part of the process to root out crime and corruption. And the second was really about the sanctity, validity, and trust of judges in enforcing the law and vindicating rights of people, their property, and our society. So it's a real great pleasure. We're going to hear from a very distinguished member of the federal judiciary, Judge Jed Rakoff of the Southern District of New York. Judge Rakoff, I think, has been a member of the bench since March of 1996. He is widely read by everyone when it comes to the financial system, when it comes to issues of white-collar crime, when it comes to so many major issues relevant to our Congress. So please join me this morning in welcoming Judge Rakoff.
So thank you very much. It's a real privilege to be here. But at the outset, I need to make a disclaimer under the judicial ethics rules, which, as you may know, apply to everyone but the Supreme Court. I am forbidden from commenting on any pending case, not just a case before me, but a case before any judge. So that concludes my talk. Thank you very much. There's a book that some of you may be familiar with, came out last year, a very prescient book, I thought, called The Tech Coup: How to Save Democracy from Silicon Valley, by Mariachi Schottky, who is the International Policy Director at Stanford University Cyber Policy Center. And in her book, she states the following, quote, "Perhaps the most avid users of cryptocurrencies have been a group that explicitly values their opaque nature, namely criminals." And based on the cryptocurrency cases that have come before me and my colleagues, I would say this statement is very well supported. Even though President Trump, who once described Bitcoin as a scam, but has now embraced cryptocurrency, the fact is that the over-promoted and under-regulated nature of current cryptocurrencies transactions strongly suggests that more cryptocurrency scams are in the offing. So I'd like to offer some thoughts as to why this is so. First, a little background. The Oxford Dictionary defines cryptocurrency as, quote, "any system of electronic money used for buying and selling online and without the need for a central bank." Although the idea of a digital currency goes back at least to the 1980s, it was the advent of Bitcoin in 2009 that really got things going. And as heavily promoted from there on out, Bitcoin and its successors promise not just convenience and savings, but also freedom from government oversight. Indeed, from the very outset, cryptocurrency gloried in the fact that it was unregulated, or as it sometimes claimed, self-regulating with the help of private parties known in crypto talk as miners, who for a fee would keep the system accountable. If this sounds a little bit like a familiar pitch, it should, because it's a variation on the position taken by many defenders of unregulated capitalism before the Great Depression. Of course, if cryptocurrency had actually succeeded in becoming a widely used and accepted form of actual currency in the United States, its effects on the US banking system and the Federal Reserve's monetary policy would have been huge. But in fact, it never really has taken off in the manner intended. True, one small nation, El Salvador, has adopted a form of cryptocurrency as its national currency, but a much bigger nation, China, has banned cryptocurrency altogether. And in the US and most other places, most people still make most of their purchases and sales in dollars and other regulated currencies. But from the start, and still now, cryptocurrency has been promoted as the wave of the future, with the accompanying suggestion that if you want to be a really smart investor, you should purchase your cryptocurrency now before its price inevitably rises. In other words, cryptocurrency has been and still is primarily marketed as a speculative investment, but with two key differences. First, what you are investing in is not some underlying product, but simply the hope that someday cryptocurrency will become a widespread form of actual currency. In other words, you're sort of gambling. And second, what you are investing in or gambling on is something that is largely hidden and opaque in its operations, hence the word crypto, and also largely free of government regulation and very proud of it. To say that these differences make cryptocurrency attractive to crooks is to state the obvious. Perhaps the earliest criminal use of cryptocurrency was to money launder. A drug lord, for example, could use his ill-gotten proceeds to purchase cryptocurrency, secure in the knowledge that the market was unregulated and the transactions easily concealed, and he could then sell his cryptocurrency at the other end of the transaction to cryptocurrency purchasers and wind up with lots of cash or other forms of remuneration not easily traced to the underlying narcotic sales. Based on this model, a guy named Ross Ulbricht developed a black market cryptocurrency exchange called the Silk Road that facilitated this and other forms of money laundering by drug lords throughout the world. But in 2013, he was caught and tried before one of my fellow judges in the Southern District of New York, Catherine Forrest, who, because of the huge size of Ulbricht's criminal enterprise, sends Ulbricht in 2015 to life imprisonment. This past January, however, President Trump gave Ulbricht a full pardon. It was the Silk Road black market that provided my first knowledge of the of how cryptocurrency could facilitate money laundering. Specifically, in 2014, I presided over a criminal case involving two men who knowingly aided money laundering on the Silk Road. Although both defendants pled guilty, I had some sympathy for one of the defendants, Charlie Shrem, who was only about 24 years old at the time, and so I sentenced the young Mr. Shrem to what was, under the guidelines, a relatively lenient sentence of 2 years in prison. I vividly remember, however, how Shrem yelled out at his sentencing that he still believed in Bitcoin and that it was the wave of the future. And indeed, after he finished his term in prison, Charlie Shrem became a leading advocate for cryptocurrency. Unexpectedly, however, I saw him in my courtroom a few years later when he was sued by the Winklevoss twins, who alleged he had cheated them out of millions of dollars in a Bitcoin investment. Now that case was eventually settled, but what I most remember was seeing Shrem sitting in my courtroom wearing a very expensive, probably Brioni suit. So the point is, not everyone who invests in cryptocurrency loses his shirt. In any event, as the cryptocurrency market continues to this day to rise and fall, often with lightning speed, new forms of cryptocurrency have been quickly developed. These include so-called altcoins, that is, direct competitors to Bitcoins. Another, perhaps more sometimes comical form of cryptocurrency tokens are so-called meme coins, that is, crypto assets named after some public figure or fad. I suppose I should be flattered that about a year ago, two Japanese gentlemen came out with a new meme coin named $Rakoff, complete with a cartoon likeness of me. And they marketed it aggressively until I got wind of it and demanded they remove my name, which they kindly did. But you can still purchase their crypto token under its new name, $Jurist, which now has a cartoon figure of a generic judge wearing a wig and the whole business. Or, if you prefer, you can purchase the meme coin that Donald Trump launched shortly before his inauguration, known as $Trump. It is true that after an initial surge, the price of $Trump fell dramatically, but who knows what tomorrow may bring, and the entire Trump family is now promoting various forms of cryptocurrency under the name, quote, official Trump. Less comically, meme coins have proven highly volatile, and investors in many of them have lost literally billions of dollars. Frequently, moreover, they involve variations on what used to be called a pump and dump scheme, but is now called in crypto jargon a rug pull. In these schemes, the promoters of meme coins hype their latest offering, causing the price to rise, and then secretly sell off their personal holdings before the price inevitably crashes. But this familiar form of fraud did not stop the newly appointed heads of the SEC from recently advising their staff that transactions in meme coins usually do not constitute, in their view, transactions subject to the federal securities laws. Still another form of digital assets, the legal status of which remains uncertain, are so-called stable coins, which are cryptocurrency tokens purportedly designed to maintain a stable value and thus counter the volatility that has made cryptocurrency so much of a gamble. But in fact, many of these stable coins have, as often as not, devolved into fraud. A good example is a case that came before me less than 2 years ago, entitled SEC versus Terraform Inc. Terraform, which was founded by a South Korean named Do Kwon, offered various kinds of cryptocurrency tokens to investors under names like Terra and Luna, but the common theme was that they were all subject to a very sophisticated but secret algorithmic trading mechanism that, it was said, would guarantee that the market value of a Terraform token purchased at $1 per token would never fall below $1 for less than a very few minutes. In other words, the suggestion was that a purchaser could never lose money. Now, even in crypto land, this was initially greeted with some skepticism, but when early on the price of a Terraform token, having fallen one morning to 90 cents, immediately rebounded to above $1, investors began to believe the hype, and the price of Terraform tokens skyrocketed, actually at one point reaching $144 per token. This great increase in value was also aided by Terraform's subsequent announcement that it convinced a South Korean mobile payment application similar to Zelle but called Choi to allow the Terraform blockchain to process and settle consumer transactions. The SEC, however, alleged that this was all a pack of lies. Specifically, the only reason the Terraform token price had immediately rebounded after falling to 90 cents was that Do Kwon had secretly arranged for a confederate to make a huge but secret investment in the tokens that caused the price to rebound. Similarly, Choi never actually used the Terraform blockchain to process its actual transactions, but simply allowed Terraform to pretend this was happening by allowing Terraform to create fake blockchain records that simply mimicked the non-Terraform payments that Choi actually was handling. Anyway, after the SEC brought suit, the price of Terraform's tokens fell to as low as 11 cents per token, and investors lost something like $40 billion. The SEC's complaint was assigned to me, and Terraform initially moved to dismiss on the ground that the investors who bought the tokens were not investing in securities subject to the SEC jurisdiction. I eventually held that the tokens were in fact disguised securities, but then not every court has agreed that this is true of all cryptocurrency investments, and the issue remains unresolved to this day, not least because the SEC's new leadership has greatly cut back on enforcement proceedings involving cryptocurrency. Before this happened, however, the Terraform case before me was tried before a jury, which found Terraform liable on all counts, including, as mentioned, a loss to investors of over $40 billion. However, the SEC then settled the case with Terraform for a fraction of this amount, but in fairness prompted by the fact that the company had then gone into bankruptcy. I should also mention that the same jury found Do Kwon jointly liable with Terraform, but I can't comment further on that aspect of the case as Do Kwon is now facing criminal prosecution before one of my colleagues in the Southern District of New York. And since this is a Stanford audience in some ways, I will somehow refrain from discussing the case of Sam Bankman-Fried and the cryptocurrency exchange known as FTX, which was tried before my colleague, Judge Kaplan. But it is perhaps worthy of mention that cryptocurrency criminality is very much a global problem. The Silk Road, already discussed, was an early example, but in February 2014, the global Bitcoin exchange known as Mt. Gox declared bankruptcy, confessing that it had somehow lost 750,000 Bitcoins, which was 7% of all the Bitcoins then existent in the world. Also, because of its dependence on digital entries unpoliced by banking institutions, cryptocurrency is particularly prone to theft by hackers, with losses of billions of dollars reported throughout the world. And to give still another example, cryptocurrency is the form that perpetrators of ransomware schemes usually demand that the ransom be paid in because it helps to further conceal their identities. In any case, two lessons can perhaps be gleaned from even just the Terraform case. The first is how easily investors are misled when it comes to something as superficially attractive but yet arcane as cryptocurrency. And second, how little regulation of this market there actually is. Just last week, for example, the SEC dismissed 3 of its largest pending enforcement actions against cryptocurrency ventures, stating that this was part of the Commission's reassessment of its approach to crypto regulation. Now, it would be far too cynical for anyone to suggest that this had anything to do with Donald Trump's change of view on cryptocurrency, not to mention the fact that the cryptocurrency industry contributed $130 million to his campaign. But in addition to the SEC's new stance, bank regulators like the Office of the Comptroller of the Currency, who might well claim to have jurisdiction over anything called cryptocurrency, have recently scaled back, if not eliminating altogether, the modest supervision that they had previously exercised over this market. In short, this much seems clear. First, the cryptocurrency market is awash in highfalutin promotions, when in fact its actual success in developing an alternative to conventional currencies is very modest. Second, the cryptocurrency market remains largely unregulated and seems likely to remain so for the immediate future, thus making it an attractive venue for fraud, money laundering, and other criminal activity. And third, the result is that investors have already been deceived into investments that cost them billions of dollars in losses, and that this is likely to continue. This, I would take the liberty of suggesting, is not a happy situation. Thank you very much.
So, Judge, I think we'll start, before we get into some of the substance of what you shared, just maybe a little bit about being a trial court judge that has overseen a lot of complex securities and financial system issues. You know, regulators often bring cases in the jurisdictions where there are major financial firms. The Southern District of New York is a common place for us to, or used to file those suits. I just wonder what you can share about the readiness of judges often to handle these very, very complex cases, which I think are not limited to financial services, but also some very other technological, and scientific. And how are judges thinking about that?
Well, first, you're right not to limit it to complicated financial cases. If you want to see something really complicated, take an ERISA case. I assure you those are much worse. So it's a question of time. Federal judges, even though we all claim to be overworked, actually have a relatively modest docket. And so we can take a day or two to get into complicated cases at the outset. And most judges are quick studies. That was sort of the common denominator of being a trial attorney, was that you were a quick study. And so that usually is enough to get you into the case. My heart really goes out to state judges who typically have 10 times the docket of federal judges, and they're just not going to be able to get into a complicated case in any deep way, and so they look for technicalities to get rid of the case rather than addressing the merits. But it's not really their fault. It's the fault of a combination of too few state judges and sort of an, if you will, an over-litigious American public.
At least in the US, but this is also common in Europe, regulators are often criticized for bringing cases on novel fact patterns where there's advances in technology, advances in what financial product offerings using sometimes older statutes, and this is pejoratively referred to as regulation by enforcement. And then there's also another path where the regulators can go through a process to develop regulations, rulemaking, for which there is significant time lags, there is significant procedural hurdles in some circumstances. So, as a judge, what do you make of the criticism of so-called regulation by enforcement? And in the current context of today's judicial environment, would there even be meaningful deference to regulations and guidance developed by the agencies?
Well, the debate you're mentioning is, of course, the one that has divided the SEC, which took the position under the Biden administration that they should go forward, and now is saying, let's wait till we can put together regulations. The beauty of the Anglo-American system of law is that the facts drive the law. And the common law recognized this from medieval times, and so allowed judges to deal with new facts, new technologies, new situations, and figure out, based on applications of prior principles, but not a wooden devotion to any prior holding, how to deal with this new situation. The greatest, in my view, of American judges, which was Nathan Cardozo, was the great exponent of this view of how the law has an adaptability under the Anglo-American system that it doesn't have under European systems, which are much more statutorily based, started with the Napoleonic Code. That doesn't mean that you don't eventually have to have regulation, because you have to provide fair notice to the parties, but it does mean that you don't just do nothing while regulations are being developed and while you're developing a evidentiary base for those regulations. On the contrary, the best guide to a regulation is to see how cases played out in actuality and how the application of already existing general principles of law guided the approach to new technology. So in the Terraform case, for example, on the question of whether these were securities or not, I applied the Supreme Court's decision in a case called Howey, which had come down in the 1940s, but which basically set the basic principles of what is a security, and that was what guided me in determining that the cryptocurrencies in that case were securities. And I think that can only be helpful in developing what is a informed regulation when that time comes.
So I'll turn it over to the audience soon, but let me ask something else, just sort of speaking personally on this. You mentioned that cryptocurrency has sought to be a system that operates really outside the sovereign and the regulated space. But at the same time, we also see cryptocurrency eager to be part of central bank or treasury reserves. We also see interest in cryptocurrency having master accounts at central banks to be able to transact through the payment systems. And the truth is I think many in the cryptocurrency industry do want there to be able to be a flow between fiat currency and cryptocurrency. But I just wonder how you think about the origins of being a separated system, but as it has grown, a desire for it to be deeply integrated into the traditional system.
Well, My general view, again, informed by the cases that have come before me, which is maybe not a fair way to view it, is that there's an inconsistency or maybe even hypocrisy operating here. The cryptocurrency devotees want to have the advantage of government access, but far be it from them to ever want government regulation. So I am not surprised that some proponents of cryptocurrency say, let's go the way of El Salvador, which I think is these days mostly a recipient of transfers of immigrants from the United States. But let's go the way of El Salvador and make it an accepted national currency. But that's fine, but don't ever subject us to the kinds of regulations that the dollar is subject to all the time. So I just find it, to be frank, hypocritical.
Questions from the audience? Curtis.
Thank you, Judge, for your remarks. You mentioned that the anonymity of crypto makes it a playground for crooks, and I wonder to what extent have transactions in the blockchain posed evidentiary problems for prosecutors, or has that not been much of an issue?
Yeah, that's been, it was once thought that it actually would help prosecutors because if you delve deeply enough, you could find out who was really involved. But then that was easily avoided through use of phony names and fronts and things like that. I think in the cases I've had, they've sometimes had problems in elementary things like authenticating records because they don't meet the ordinary business record criteria. So there's been those kind of complications. But I think overall the problem is one of secrecy.
Rick. Go ahead.
I'd like to go back to the question our moderator presented about regulation by enforcement. One of the complaints that American businesses have about the Foreign Corrupt Practices Act is its regulation by settlement. Because the consequences of an indictment to a company are so tremendous.
Yeah, it might actually have to pay some money.
Well, but you're excluded from bidding for federal contracts. There are all sorts of consequences, right? So the complaint is that whatever people in the Justice Department say is a violation of the Foreign Corrupt Practices Act, we got to accept it because we can't risk even the indictment. So it's their complaints, regulation not by enforcement, by regulation by settlement.
Well, that's a very good point. Part of the problem here is the difference between federal and state law when it comes to corporation liability. So under federal law, and this goes back to the 1890s, the criminal act of even a low-level employee is imputed to the corporation. And that makes it very difficult for the corporation not to come to the bargaining table. In many states and under the model penal code adopted by many states, it's only high-level managerial people whose acts are then imputed to the entire corporation. And I do think that makes much more sense, the model penal code approach. Companies could go much more easily to trial if they were simply facing what some low-level employee had done that was beyond the pale. But you should also recognize at the same time that most of these settlements that you're referring to are usually relatively less than the profits made by the illegal activity. So the great, there are two professors who've written extensively on this, Jack Coffey at Columbia and Brandon, yes, at Duke. Anyway, I'm at the age where I forget names. Actually, I forgot them even when I was 20. And they have shown that the penalties paid in dollar terms by these corporations are considerably less than the profits that were made by the illegal activity. Not in every case, but in a great many of these cases. So my heart is not bleeding for the corporations. But I understand your point, and it's one reason why I think it's a very bad thing that most of these cases do not go to trial. It's a trial that really puts the system to the test. This goes beyond your particular area. As many of you may or may not know, 97% of all federal criminal cases of all kinds settled by plea bargain. This is a terrible thing because it's really a trial that tests the whole situation. And it's a function of many things, but mostly overly punitive laws that were passed with bipartisan support in the last part of the 20th century when crime rates were rising. But it leads, as you say, to, in effect, the government is making the regulation by force, not by due process. So I think that point is well taken.
And Rick, I'll just comment on that, that there is a bad habit. I remember when I got to the Federal Trade Commission in 2018, and the agency was, essentially dead. And the only thing it was doing was essentially going after very small businesses, strong-arming them into settlements, and then saying, look at what we're doing. But they would say, well, the reason we don't go after big ones is because we will face so much pushback. And I think you have a lot more legitimacy when you go after the biggest players and you litigate, to a judgment. Professor Fukuyama.
Yeah, Judge Rakoff, thank you for that overview. One of the least remarked Supreme Court decisions from the last term was Jarchese versus SEC, which it seems to me severely weakened the SEC's ability to enforce rules. Can you comment on that? Has it had an effect, and what do you expect going forward?
Well, it's too soon to know what effect it will have. Putting cryptocurrency aside, where the SEC is very clear that it's cutting back on its prior aggressive approach, I haven't seen yet a reduction in SEC cases. The Southern District of New York is a good place to see this because that's where a great many of these cases are brought. The Supreme Court is not fond of the regulatory state, that's obvious. What I think is a shame is the inability of Congress to step into the breach. I'll give you an example. For now decades long, inside information liability has been judge-made law. And not because Congress hasn't had people suggesting here's a model statute, but because they just can't get their act together. And virtually every session there's a proposed bill of one sort or another to define what is or is not insider trading, and it never gets passed. The result is that the law of insider trading is being made by judges. Now, on the one hand, as I indicated before, I think that's better than no law. But on the other hand, it does inevitably lead to some uncertainties, to some internal inconsistencies, to differences between circuits and things like that. And so it'd be much better to have a federal law in this area. And given the tendency of both the current administration and the Supreme Court to cut back on the regulatory state, it places the burden even more on Congress, but it's a burden they so far have not chosen to accept.
Hi, I'm Chanu. I'm MBA 2 student at Stanford, and I actually work in stablecoin industry. So going back to our stablecoin conversation, now there are 2 bills about to be passed at the House and also at the Senate. First, supporting stablecoins actually to be regulated fully by the government, and that is actually fully supported also by stablecoin industry. So if in case that the industry wants to work together with the government and also want to be fully regulated, I wonder you also see that as a like a problem. I think also that these bills that's about to be passed is actually supported by bipartisan support, because this is actually reinforcing dollar dominance in the global economy. So it seems like it's not just the Trump administration, so both parties actually in support with this movement. I'm just curious about your comment on this.
Well, I'm interested in what you say, but I'm not totally sure what the question is there. The cryptocurrency, it's hard to speak of the cryptocurrency industry because they are a diffuse group. Many people being from various countries around the world, and they don't come together in many respects. But it is true that they have occasionally said we want to work with the government on appropriate regulation. And I guess my rather cynical view of that is every time when I was a prosecutor and I brought a case against someone, his or her or its attorney would come in and the first words out of their mouth was, "We want to cooperate," and their nose should have grown at that point. So I'm a little skeptical of that.
Well, please join me in thanking Judge Rakoff.